Hello, everybody. I'm Ben Barrows. I'm the Dean of the University of Toledo College of Law. Welcome back to our second session with the NCBE and related bar examiners on the bar exam. This one is on the future of the bar exam, a testing task force update. So let me introduce our panelists. We have Kelly Early, who's the Chief Strategy Officer at NCBE, and I have to say one of the most knowledgeable people about all of this stuff I've ever met. We have Cindy Martin. Judge Martin is the Chief Judge of the Missouri Court of Appeals. She was the chair of the testing task force. And she also, it would take me 15 minutes to go through it, is one of the most experienced bar exam related people I've ever met for, I think 20 years or more, has been heavily involved in the bar exam on various different levels, and has also been involved in ABA accreditation. So we're really glad to have her with us. We have Mark Raymond, who is the Director of Assessment Design and Delivery at the NCBE. He is a PhD psychrometrician. And we have Greg Bordelon. Greg is Associate Professor and Director of Academic Success at the University of Maine. He's worked at another law school and also was Executive Director for the Louisiana Supreme Court Committee on Bar Admissions. And also, I'm moderating, but I also have played a little bit of a role in this process, so I'll also be participating a little bit. So to kick things off, I'm going to turn things over to Kelly Early. Kelly, take it away.
Thank you, Dean Barrows. I'm going to share my screen here quickly and get the slides up for everyone. Can you see the slides now? Okay. It didn't seem to open it in PowerPoint on my iPad, but we'll try to get by with this. So thank you everyone for joining us today to discuss the Testing Task Force preliminary recommendations for the next generation of the bar exam. This set of recommendations was published on our Testing Task Force website this week on Monday, January 4th, so we hope you've all had a chance to read them. We deliberately kept the overview of the recommendations brief to make it easy for you to read through and digest, and we are hoping to provide more information for you in this session. I'm going to be starting by outlining the process that we have followed in our research study to arrive at these recommendations. Then Judge Martin's going to tell you what the recommendations are, and Dr. Raymond will expand upon some of the measurement aspects of the recommendations. Then Greg Bordelon is going to talk about implications for academic support and those of you working to prepare students for the bar exam. And then we will end with Dean Barrows leading us through a question and answer session to answer any questions you may have after we've completed our presentations. So, see if this moves to the next screen. Like I said, it didn't seem to open in PowerPoint, so I'm just going to be scrolling it. Hope that works. We began the study in January 2018 to ensure that the bar exam keeps pace with the changing legal profession in a changing world. And we undertook the study. That decision was in keeping with what is common in terms of best practices and the professional standards for testing, that a testing organization should periodically undertake a review of the contents that is tested for a licensing exam. But we went beyond that and undertook a wholesale review of everything about the bar exam. So not only content, but also the format and structure of the exam, the delivery method, and the timing of when it is administered. We have arrived at this set of recommendations based upon qualitative and quantitative data that we gathered during the study and informed by the opinions of stakeholders. The study has been undertaken in a very collaborative fashion with stakeholders from the bar admissions community, from the legal academy, and practitioners. We have also been ably advised by testing experts, not only through our independent research consultants at ACS Ventures, but also the independent psychometricians who serve on our technical advisory panel, as well as our own in-house experts such as Dr. Raymond, who are on NCBE's staff. So as I mentioned, we published the preliminary recommendations this week, and you are all, I hope, anxious to hear what they are, but also anxious to hear, when is anything going to happen? When is anything going to change? What's going to happen next? Well, in addition to this session at AALS, we are having webinar sessions with bar admission representatives this month as well, and we have published the recommendations on the website and are inviting questions and comments via the Contact Us form on that website. We'll be compiling the questions that are submitted and produce an FAQ that we'll post on the website. That website is also where you can find all of the reports we've produced as the part of our study. And once we heard from stakeholders, we will be finalizing the recommendations to submit them to our Board of Trustees at the end of January. We will be producing a comprehensive report of our study in the spring, which will get published on the website. And so I hope you can rest assured that yes, the bar exam is changing. We realize this is no small undertaking, but NCBE has the necessary experience and the expertise to accomplish this. We are positioned to work smoothly and seamlessly with the jurisdictions, as we have for decades, to accomplish it. We are committed to doing this over the next 4 to 5 years. For those of you wondering, when will we see a new bar exam? We know this is an ambitious timeline, but as I've said, we're committed, and we have the expertise and the experience and the infrastructure needed to do it. So we will continue as we begin and undertake implementation of these recommendations to involve stakeholders in the process. And at the end of our slides today, you'll see we've mapped out at a high level what the many steps in implementation are, to give you some idea of why it's going to take at least 4 to 5 years to get there. So I see some of my graphics are also missing from this version of our slides, but we have designed this study in 3 phases. So phase 1 was when we reached out to stakeholders and had listening sessions with them. Phase 2 was a nationwide practice analysis survey. And phase 3 was when we dug in using the data from phase 1 and phase 2 to determine what the content and design of the next generation of the bar exam should be. So in these listening sessions that we held during phase 1, we had 30 sessions held at 10 events over a course of several months. Many of you participated in sessions we held at the AALS annual meeting in January of 2019. We also had several sessions at the AASE educational conference in May of 2019, as well as a session that we co-sponsored with LSAC, an educational conference in February that many of you attended and participated in. And we had a session available for deans at the ABA's Dean Workshop. So we had many opportunities in particular to hear from the Academy, which we have appreciated greatly, your input and participation. We generated a report of phase 1, which is on our website. And I would say primarily we heard you, you really liked the MPT. You begrudgingly appreciate the role that the MBE can play in reliability, but you feel that we are putting too much emphasis on the testing of legal doctrine and not enough emphasis on the testing of skills. You also feel that we're testing too deeply and too broadly within the subject areas that are covered on the bar exam. So those were just a few of the main takeaways we got from phase 1 in the listening sessions. We moved into phase 2, which was the practice analysis survey. This is how we collected quantitative data on the job activities that newly licensed lawyers perform and asked questions about what knowledge, skills, and abilities and other characteristics they need in order to accomplish their work. This resulted in a very robust and rich set of data. We organized the survey with the general license in mind. And by that, I mean we did not grouped these job activities or tasks that we asked about under categories of practice areas or areas of law. That has some intuitive appeal, but we realized when we started working on developing the survey that created many redundancies, and that job activities are common across a lot of practice areas. So we also were very sensitive that organizing by practice areas would have meant us putting our thumb on the scale, so to speak, in that we would have been choosing which practice areas to include and which to exclude from the survey. And that would not have been consistent with our guiding principle to undertake this study unencumbered by what is tested on the current exam. So instead, we organized the survey around 4 broad categories of general lawyering tasks, litigation or dispute resolution tasks, transactional tasks, and regulatory compliance tasks. We also recognized I mentioned that we asked about other characteristics, and some of you may think of that in terms of soft skills. That's like diligence, self-awareness, collegiality, etc. While we recognize that some of those things may not be able to be objectively tested on a bar exam, we viewed this survey as providing data for the legal profession, not just for NCBE and for our use in crafting an exam. So we thought this survey would provide a lot of good data for legal educators, as well as for employers and bar associations who engage in post-licensure training and mentoring activities. The survey was administered online from August 1st until October 1st of 2019. We received nearly 15,000 valid responses overall. And by valid responses, I mean that the individuals answered all of the questions that were posed to them in the survey. The respondents were representative of the U.S. lawyer population according to the ABA's 2019 profile of the legal profession. So we were very pleased with not only the size of the sample that we obtained, but also the representative nature of it. We produced a detailed report of that practice analysis in March of 2020. And with the data from phases 1 and phase 2 of our study, we moved into phase 3 this year. We had to switch to hold phase 3 online or virtually rather than in person, but we convened 2 committees of stakeholders. The first was the Blueprint Development Committee, which was composed of practitioners. These were newly licensed lawyers and people who supervise newly licensed lawyers, none of whom had any connection with the bar exam or NCBE at all. Their focus was on what do newly licensed lawyers do, what content should be tested, and they gave no consideration to what is currently tested on the bar exam. They came up with the content that should be tested, and then we convened the test design committee. And in contrast to the Blueprint Committee, with the test design committee, we wanted people who are familiar with the bar exam and know something about it. So that committee was composed of legal educators, including Dean Barrow and Greg Bordelon served on the test design committee. Thank you very much, as well as others of your colleagues from the academy, and bar examiners, bar administrators, and justices. And that committee determined how should this content be tested. We issued a detailed report of the phase 3 portion of our study that documented the work of these 2 committees, and that was published in November of 2020. And so with that, I'm going to turn it over to Judge Martin to tell you what the recommendations are.
Kelly, thank you very much. Boy, we're very, very excited to talk with you about those recommendations. And Kelly has just distilled in about 10 minutes 3 years of very intensive, purpose-driven research that has been designed to gather a substantial amount of data and information and input from many of our stakeholders to put us in the best position to arrive at recommendations for the future bar examination. As you might imagine, even that process has required the testing task force to engage in a very systematic decision tree, so to speak, so that we could distill that information. And in the case of decision points involving tension, where we have received competing opinions on a variety of subjects, working through to reach the best decisions about what the recommendations should be. In the process of doing that, we have been driven by what we consider to be very important prevailing themes, not only being true to the science that Kelly has just described to you, but also thoughtful of the prevailing themes that came out of that research, particularly from the phase 1 listening sessions, and driven by themes involving applicant fairness along the lines of making sure cost is not substantially greater, if at all. We're not impacting portability of score, that we're sensitive to the notion of not releasing scores any later than already occurs, if possible, even sooner. Understanding that one of the objectives is to try to focus more on skills and performance assessment and less on doctrinal assessment as well. In addition, we needed to be driven by the best practices in high-stakes licensure exams, and those fall essentially into the categories of validity, making sure that you're assessing what you say you're assessing, and reliability, so that the scores that are derived are consistent over time. But as you see on the slide, the paramount objective of our work has been to be true to the purpose of the bar exam, which is a public protection assessment tool designed to help ensure that those who are newly licensed possess the minimum knowledge and skills to perform activities typically required of an entry-level lawyer. And you have to keep in mind, of course, with that, the point Kelly made moments ago, that entry-level lawyer is attaining a general license. That in and of itself became thematic to us as we looked at what should be the categories of knowledges and the categories of skills assessed on the exam. You're going to see, if I could turn to the next slide, that our recommendations fall essentially into 6 categories: recommendations involving content, structure and format, frequency, delivery mode, scoring, and timing. I'm going to speak for just a moment about content, then I'm going to ask Dr. Raymond to speak with you about the structure, format, and scoring of the exam recommendations, and then we'll turn back to timing, frequency, and delivery mode. With respect of content, we recognize that the practice analysis was giving us information about those tasks, knowledges, and skills that rose to a high level of importance. And then through our BDC and TDC exercises, those high level of importance items were distilled even further to these foundational concepts and principles that transcend practice areas. In other words, they involve principles of law that universally are perceived to be important to every lawyer, regardless of the practice area you may be in, and thus, again, consistent with the purpose of the exam and the notion that people are going to be achieving a general license. The civil procedure area will include constitutional protections as well as practice before administrative agencies. The contract law area would also include Article 2 of the UCC. Business associations would also include agency, and constitutional law, of course, would include all the constitutional principles not already covered in civil procedure or in criminal law. Key here is not just that we're reducing the number of knowledges being assessed, however. It is as well a commitment as a part of the implementation process for these recommendations to a systematic plan to develop content specifications that do 2 things: that fairly advise applicants of what it is that they need to know, what they're going to be assessed on the bar exam, and that are driven by the practice analysis to avoid an issue with the scope of the content specifications being too broad or too deep. We understand and heard that refrain from many of our stakeholders and already have in place as a part of our implementation thought process a protocol that will draw upon subject matter experts to ensure that the content specifications not only reflect the fewer areas of the law will be assessed on the exam, but that within each of those areas of the law, we will be consistent with what truly is expected of a newly licensed lawyer. We also are increasing the emphasis on skills on the bar examination of the future. And if we could move to that slide, please, Kelly. The skills that will be assessed on the bar exam of the future are those that are listed here. And in fairness, some of these skills already are being assessed on the current bar examination, but the manner in which the current bar exam is structured may not make that evident to you. Certainly, we will be looking at item types and item structure in the future that will permit us to assess the skills that you see on your screen. One thing that I think is important to point out to you, though, we are very sensitive to the fact that the skills assessment has to be fair to applicants. So we are not going to be talking about skills assessment that is overtly costly, that is using subjective mechanisms and or non-uniform materials or expensive undertakings. Instead, we will be talking about uniform assessment with uniform materials, not in a performance or competition type of a scenario, but actually working in the essential skills as each of these categories might require to demonstrate minimum competence. The key with the reduction of knowledge areas and the increase in foundational skills, however, is really best translated when you look at what our recommendations are going to involve in terms of the structure and format of the exam. We are going to be moving to an integrated exam format. And an integrated exam is one that assesses both foundational concepts and principles and foundational skills holistically, using a combination of item formats in settings that more closely approximate the real-world practice of law. So I'd like to turn it over, if I could, to Dr. Raymond to speak to you just a little bit more about the structure, format, and scoring of the bar exam.
It is a pleasure to join you here today. And I would like to thank you all for your attention and for coming. And boy, like Kelly and Judge Martin, I'd like to express my enthusiasm and my excitement for being able to be part of this project. So what I'd like to do before getting into the details of what an integrated exam might look like, quickly review the structure of the bar exam today. And we could go to the next slide. So most everyone here is familiar with these three components. A key feature of the bar exam is that these components are separately developed, administered, and later scored. And they remain independent until the end of the process when we combine the scores into a single score. So this process really runs like a well-oiled machine and has served the profession admirably for years. It's widely recognized within the legal profession and even across the measurement community as a reliable assessment package. But while there are certain features we will leave behind, I want to make clear that there are other parts of the current exam that we will carry with us into the future. Next slide. So here's a stylized depiction of what an integrated exam might look like. In the outer circle, shaded as green, we have the foundational concepts and principles, or the FCNP. And you also see the foundational skills there, or FS. Now, an integrated exam aims to assess both knowledge and skills at the same time. In the center of the diagram are the legal problems that candidates are expected to address and the resources necessary to solve those problems. The graphic doesn't quite depict that anymore, but it's in there somewhere. So meanwhile, these blue cogs represent the test item formats that allow candidates to demonstrate their knowledge and skills. And as you can see here, the exam of the future will include some of those item formats that resemble the current bar exam. Next slide. So in its simplest terms, an integrated exam is about two things. First, it's about making connections. Connections across content areas. And connections between knowledge and the ability to apply that knowledge. and also about connections between what is learned in law school and what is done in practice. Is there a little feedback coming through on everyone's monitor audio? I'm going to turn mine down. I'll turn mine.
I don't know if you can hit mute. It might be coming through yours.
I'll turn down a bit and see if I can get rid of that.
And Mark, my iPad is not displaying the slides in PowerPoint, and therefore the animation on the right may not show up. I'm sorry about that. Didn't know that was going to happen.
I think we can get through without it if it doesn't. And it may take one more click to get there, too. Is the audio a little better now?
Yes.
Okay, good. I may have just had my volume too loud. So, integration's about connections. And in particular, it's about the connections between what is learned in law school and what is done in practice. So the second aspect of integration is that it involves item sets. An item set is several test questions that relate to a common scenario that present a practical problem. Integrated item sets will be challenging to develop, but computerized test delivery will facilitate that and enhance their feasibility. For example, different types of test materials might be organized under different tabs on the computer. And computerization also expands the reference materials that can be made available to candidates. And it enables new item formats beyond the 4-option MCQ. And I'll be happy to describe some of those new item formats during the Q&A session if anyone's interested. So maybe the right-hand part of that slide will show up if you press enter one more time.
It's not going to show up. I can't. It's not in PowerPoint, and there isn't anything to press. Sorry about that.
Nope, no problem. So what this right-hand slide would show is a file folder, and that file folder would have in it case information. It would also show a legal library, and it would also show item formats. And so these are the different components that we anticipate an examinee would see when they open up their computer screen. So I'd like you to imagine for a minute what an examinee might see. So they would sit down at a computer and they would see a description of a legal task to complete. So across the top of the screen might be tabs for the case file, a legal library, and a set of test items. So the candidate would click on the case file tab and a scenario would appear. And it describes a client who wishes to purchase, say, 200 pounds of fresh shrimp for a business event. And the contract with the seafood supplier indicates a delivery date, but instead of a specific price, it states market price. So the candidate's first task here is to identify the fact that market price probably is not in the client's best interest and to propose a counteroffer. The counteroffer could be a writing task, or the candidate might be provided 4 choices to choose from that have already been written, where each choice is an alternate wording of the counteroffer. So moving on a little bit, and one might imagine a second test question pertaining to that same scenario that requires the candidate to determine what follow-up information or questions they might ask to ensure that the client's interests are protected in other ways. And the scenario might go on to include delivery of an inferior product, like maybe the shrimp are spoiled. So here the candidate would be required to identify which UCC regulations or state laws are relevant to the problem. And of course, the laws and regulations would be available in an online delivery. So by the end of this item set, the candidate has had to spot issues, apply writing skills, investigate and analyze, and also advise a client. So while this is just one vision, and it could change somewhat, but assuming that some of this vision is realized, I still think it's fair to say that item sets won't make up the entire exam, and we will probably expect to see standalone MBE type questions on the bar exam of the future. And I'd like to say a little bit about where this notion of an integrated exam came from. And our test design committee considered various item formats during their work. And one of those, the ideas that came up and it really resonated, was the idea of having a single scenario that would relate to several questions. Then a few weeks after that, we met with our technical advisory panel, a group of psychometricians. They also independently mentioned the value of integration. But where integration really came from, it started before that. It started with you all, in higher education, where people recognized that it was useful to combine different foundational pieces of subject matter to integrate them when teaching, and that it was also useful for teaching and for assessment purposes to integrate them into practice. So there is a bit of history to this idea of integration. It started first with integrated curricula and then moved on to integrated test item formats. The next slide. And the next slide, I think, is going to talk about scoring models. So our committees considered various methods for tabulating scores and making pass-fail decisions. The current bar exam is based on a compensatory model, not a conjunctive model. And as you might suppose, the integrated exam of the future pretty much demands a compensatory model. The knowledge and skill components are so intertwined that it just does not make sense to disentangle them into separate passing scores. I'm not going to go over the details of this slide. There's a lot of technical matter to it, but if you do have questions, please do not hesitate to ask them later. So with that, I'd like to turn it back over to Judge Martin to explain other features of the bar exam of the future. Thank you.
Thank you, Dr. Raymond. Integration is very exciting, and it's also one of those things that, as Dr. Raymond alluded to, will take a lot of time and effort to develop test questions that approximate real world and that give us the opportunity to integrate a variety of item types around central case scenarios or case resources. I've been monitoring some of the chat questions that are coming across, and you're raising excellent questions. And frankly, in every case, they are all things that are already on our very long list with respect to implementation. And we're going to talk about that in a minute. But the takeaway today, I hope that is exciting to all of you, is the notion that the discrete components of the current exam will no longer exist. And instead, through a series of integrated item types or item sets, the new exam will produce a bar exam score. And we'll use this integrated holistic assessment method to present materials to applicants in a way that feels like the practice of law instead of artificial discrete components, which, although are appropriate assessment tools, nonetheless do not have that same connection, as Dr. Raymond described. The natural result is the timing of the exam needs to remain as a single event summative exam at or near the point of licensure. Not only is this most consistent with the purpose of the exam as earlier described, and consistent, of course, with the notion of an integrated exam, it also avoids a litany of concerns, frankly, for both jurisdictions and others about a multi-event approach. We heard loud and clear the input, and it was incredibly good input from many about the notion of a component-driven exam being offered at varied times in the licensure process. That concern is resolved with an integrated exam. And as well, we felt strongly that the single event summative exam eliminates confusion with respect to the fact it is, in fact, an assessment of readiness for licensure as opposed to a diagnostic tool. And it eliminates the concern that was expressed by some, frankly, in the academy that any portion of the exam being administered during law school would create confusion with respect of legal curriculum and, frankly, have the unintended consequence of perhaps distracting your students away from some of the wonderful experiential learning opportunities available to them in the academy. The collaborative work that we expect to happen through implementation will still allow us to work well with your academic support and your legal professors, but the academy and the importance of legal education will remain discrete from the bar assessment tool itself. The exam still would be offered twice a year, as is currently the model. With respect to delivery mode, Dr. Raymond already alluded to the fact, if we could change the slide, Kelly, that the delivery mode will be on computer. You're raising great questions in the chat, again, about things that we are already thinking about in terms of accessibility, in terms of making sure that the materials are not so voluminous as to be unfair to our applicants, in terms of making sure that the fact of the computer being the basis for administration doesn't create its own unintended consequences. But to be clear, the kind of computer-based administration we are talking about is in-person proctored administration, either on candidate laptops, at jurisdiction-managed sites, or at computer testing centers with a suitable vendor. We have 4 to 5 years to work that out. But the use of a computer is something that the TTF committed to very early in its work, recognizing that it does create more flexibility in terms of item types. Frankly, it is more in keeping with the technologies that our applicants are experiencing and expected to know as a part of the practice anyway. But that will be the delivery method. As we move forward from here, Kelly already talked to you about the next steps for the TTF. If we could move to the next slide. I think one thing that you need to appreciate with respect of implementation is we are talking about a lengthy 4 to 5 year process, and we're going to need every bit of that. The same diligence, the same commitment to transparency, the same commitment to systematic assessment and collaboration that has brought us through the last 3 years with the testing task force will now shift into the implementation steering committee and to the development of the new exam itself. That's going to include that all-important development of content specifications that I referenced earlier. It's also going to include the development of new test questions that are of an integrated nature. We will be focusing on accessibility issues for our candidates. We will be focusing on field testing of new item formats and exam content. We will be focusing on analyses and review to ensure fairness for diverse populations of candidates. And in the next slide, you'll also see we're going to be looking at the varied options for computer delivery of the exam. Then there are a whole host of things that we will need to work with our jurisdictions to coordinate, including scoring processes and psychometric methods for equating and scaling scores. Because remember, the all-important principles of high-stakes licensure will translate into this new exam so that it is a valid exam and it is a reliable exam. That is a given. We will be looking at new test administration policies and procedures, assisting jurisdictions who are likely going to be needing to adopt new rules and perhaps set new pass scores, because obviously the score scale will change. And we want to make sure that we provide ample opportunity and time for applicants to be familiar with what the new exam is going to require and what it will require of them, what it is that they need to know, and so that the academy as well is in a position to respond. That will involve, obviously, the preparation not only of sample questions, but study materials as well. That brings us to the end of the formal TTF presentation, and I think at this point we'll be turning it over to Greg Bordelon to discuss some additional issues with you.
Thank you, Judge Martin. I'm getting a little bit of feedback. Yep. Okay, how's that? Can everybody hear me? Okay, good. So I'm not going to do it as part of the slides, but what I did want to talk about for a little while, particularly to my colleagues in academic success and what I've learned over the last few days, is we are all in this together. And the presentations that I have had the privilege of attending the last few days have shown that very clearly, that we all as a multifaceted stakeholder into a group are interested in reforming not licensure per se, but access to justice, the diversity of the bar, and making sure that clients of lawyers have good, competent lawyers who are fit to practice law. So I want to talk a little bit about my background, not to sort of be egotistical, but the idea of why I think it's important in the context of what we do in academic success and how it informs the goal of ensuring minimum competency. So I was a pre-law advisor for 5 years, and then I had the privilege of serving as the executive director for the Louisiana Board of Bar Examiners. I know a lot of us in our group sort of jokingly say, well, we're talking about all these issues except Puerto Rico and Louisiana. But what Louisiana did for standard setting in the context of drafting its own multiple choice questions really did give me some very good introspection as to what it means to draft an instrument that would be valid in the context of what the judiciary's mission is, that is to say, to protect the public. And so those psychometric validations that I have seen as a member of the testing task force and the third phase are very important, and I think and I hope that they will continue to be looked at through the time frame through which we will adopt these proposals, that 4 to 5 year time frame, which is tight. But I want to say first, I am an advocate for my students, but I also hope that we would all be advocates as academic success professionals. We've got one of the best listservs, it's Rowdy, that we can bring these concerns to the dialogue as to whether or not these are the proposals that we think, in the interest of ensuring minimum competency and protecting the public, that are the ones that we want to achieve. I can also say, as a member of the test design committee, I've seen some of these in the chat, and there are full reports for all phases that were released after all of the work was done for the 3 phases before the preliminary proposals came out, that there were a lot of heated debates among members of the academy, academic success, doctrinal deans, as well as judges and lawyers about what we think in that multifaceted arrangement the bar exam should be. So the idea of step testing, for example, there are pros and cons to that. And the preliminary recommendations show, again, from a psychometric standpoint, in my opinion, that this is the best way to proceed to advance minimum competency in the age that we're in now. So the one thing that I want to end on really and focus on is the idea of how are we as academic success professionals going to prepare our students for this, because I think that is the biggest thing that we are concerned about. And the item set entity is the one thing that I think I'm going to focus on. I know that the deliberations and the ideas from my colleagues in academic success are going to flourish into some of the creative things that we can do to prepare our students for the baseline minimum competency exam, that is the bar exam. But I also believe that the National Conference of Bar Examiners, in responding to stakeholders' opinions, will be transparent in releasing examples. So what can we think an item set will look like? What will be the combination of foundational questions or questions of foundational subjects vis-a-vis foundational skills? If you're going to pull back on some of the perceived specificity of some of the current items of the multi-state bar exam, what remaining subjects within those 7 main subjects are we going to have a discussion about in law school curricula, for example? So there were multiple studies that have happened that I know, because I heard it in phase 3 in the test design committee, that the testing task force did look at. And I think in the interest of being a diverse stakeholding group, we're all in the same objective, we're all in this together, that we're going to see a lot of the same or similar concluding proposals as to what we think the future of a minimum competency instrument should look like. So me personally, and I know ASP will have a lot of discussion of that over the next few years, I cannot wait, however nerdy that sounds, to grab a couple or a lot of existing multi-state performance tests and start retrofitting those puppies into multiple choice questions, short answers, and anything that I can think that will look like a perceived integrative item set exam. And so I just want to say that I am behind this. I hope that as multifaceted stakeholding groups, we can get behind this in the interest of ensuring to help the judiciary's mission of protecting the public and creating a fair minimum competency exam. But I also am looking forward to a very, very involved, multi-compounded, transparent discussion at every step of the way with the National Conference to ensure that our students are not going to be blindsided by the exam. And I do not think they will. So thank you for the opportunity.
Great, thanks. So I'll just add a couple of comments of my own, and then we'll go to questions, and there have been a bunch of the great ones in the chat. So from my own standpoint, one thing I'll just say is that all of us who care a lot about bar exam or professional testing have certain issues that are near and dear to our hearts. For me personally, My big issues are step testing, as Greg mentioned, which is the idea of maybe not having one big exam, but breaking it into components. And also for me, I personally think it would be great if we could have the bar exam completed during law school for various reasons. I think that would help us support our students. But I also really hate the fact that students have to wait 6 months before they practice. I think there are equity issues and other things that leads to. And so, when I was able to participate in this, I was very much advocating for that. And the basic things that I was advocating for are not reflected in this proposal. That said, I still think it's a good proposal. And so all of us are going to have some things that if we were the emperors of the bar exam, we would do in a particular way that are not going to be reflected in this. But I'm really impressed at how thoughtful this is. I'm just tremendously impressed. And one of the things that I really like is I think that this proposal can be credibly seen as saying that our students don't necessarily have to memorize the law to the great depth that they have to do now. As a professor, that's something that I think is really important to me. Ideally, this is something that ends up being developed, that the prep is not a 7 or 8 week cram course, right? You don't have to do that. And if that's the only positive thing that comes out of this change, which I don't think it is, that's good for me. So I'm really, I am impressed at the care and thoughtfulness that is evidenced by this set of information. So let me start turning to questions. Kelly, I'm going to kick this one to you. There were some questions about the IAAS report. Could you just address that quickly?
Sure. I was trying to run slides and peek at the chat, and I did see a few comments. I don't know if I read them all completely and entirely. I think some of the questions were with respect to the IELTS report, which certainly we had seen we read their Foundations for Practice report that came out a few years ago. We also were very impressed by their thoughtful recent report, which involved a series of focus groups that they conducted around the country. Those we have taken kind of different approaches, if you will, to the process of gathering validity evidence is what we would call it, but what they refer to as sort of defining minimum competence. But what is it that newly licensed lawyers do and need to know? What is minimum competence, I think, is how they phrase the question. So we used a practice analysis survey, which is common and in fact, I think pretty much expected under the standards for high stakes testing. If you're going to have a licensing exam, it should be supported and based upon and draw from a carefully crafted practice analysis survey like we did. In fact, Dr. Raymond is one of the foremost experts in the country and in the testing industry in the area of practice analyses. Before crafting that survey, we had a focus group with newly licensed lawyers and supervising attorneys to talk with them about many of the things that the IELTS focus groups covered. In crafting the survey for our practice analysis, we convened 3 more focus groups of newly licensed lawyers and their supervising attorneys to, in essence, they largely crafted the survey questions, and they did that by talking about what it is that newly licensed lawyers do and what they need to know. And they were newly licensed lawyers coming from a variety of practice areas and practice settings with a lot of different experiences. After getting all of this data, which we were able to subject to numerous types of analyses, or Dr. Raymond was, not me, statistical analyses, the Blueprint Development Committee, in essence, was yet another focus group. It was practicing attorneys and supervisors of practicing attorneys who took this data and talked about what is it they do, or what do the newly licensed lawyers that they supervise do? What do they think is important to be covered? What can fairly be covered and should be covered in the exam? And then lastly, I would say that during implementation, we will in essence be involving more what could be called focus groups. We will be convening practitioners and academics to help us determine and prepare what we're calling the content specification. So that's when we'll really get into the nitty gritty of, so what exactly should be tested under contract law? What is minimum competence and what is going too deep and going beyond those foundational concepts and principles? So I think we have very complementary studies, and I think we should all take a lot of relief in that the very well done study that IELTS conducted this year involving focus groups and the practice analysis that we conducted this year and our previous practice analysis and other sources of validity evidence do all come together, and we look at all of it to determine what is it that we need to be testing. So, we welcome and value these other sorts of studies, and we look at them, as Greg said, and looked at them in preparing for the work we've done this year.
Great, thank you. So as far as subject matters, family law, UCC Article 9, wills and trusts, they're not there. I think some faculty members who teach in those areas are probably pretty sad about that. Can you just address that fact? I don't know, Kelly or Judge Martin?
Sure. It's interesting because when our BDC and TDC did work with the data from phases 1 and phase 2, we had a number of practitioners actually from some of those discrete practice areas who themselves were universally saying, it's an important practice area, but it is not something that needs to be assessed on the exam. One of the things that we heard loud and clear from our stakeholders is that you cannot assess everything. And it starts to be one of those aha moments when you start connecting the notion of a general license with the concept of foundational principles being really the extent of what should be assessed because they transcend practice areas. So it's not a statement of importance or a lack of importance that family law or estates and trust or conflicts of law are no longer assessed on the bar exam. And in fact, those are important practice areas that should still be and must still be areas of law that applicants as law students are exposed to because it may be their particular passion or interest in terms of their future career. But the foundational concepts of those areas that are identified earlier in our slide presentation are in fact those principles of law that are going to transcend many, if not all, practice areas. So the principle is to reduce the knowledge domains to those that are foundational in nature and not practice area driven.
Great, thanks. There's a question about a standalone MBE and whether a standalone MBE will continue to exist. And I guess that probably comes into two questions. One, will a standalone MBE be part of this new exam, which I believe the answer to that is no.
That is correct.
So there's that. I guess there might still be, is it fair to say, well, will there need to potentially still be a traditional UBE if some jurisdictions don't move in this direction? Or what is, I know we're early in the process, but what's the thought on how that might look?
Do you want to take that, Cindy, or do you want me to?
Sure, yeah. I mean, from a practical standpoint, we already have 40 jurisdictions who have demonstrated a recognition of the genuine value in uniform bar examination materials to applicants. Not only is it a benefit to applicants because of uniformity in terms of preparation, but a benefit to applicants in terms of the ability to achieve a portable score. And we have no reason to believe, notwithstanding that jurisdictions are always free to do what they wish in terms of their licensure requirements, and that includes the bar exam. We have no reason to believe that with the demonstrated expertise that we bring to the table and the commitment that we have to this new exam product, that we won't continue to see that level of commitment from the great majority of jurisdictions. Having said that, we also service all jurisdictions, and that includes jurisdictions that are non-UBE jurisdictions. The bar exam of the future is what we've described, but to say that we are not going to work with the other jurisdictions to the extent they do not elect to utilize the bar exam of the future is not an accurate statement. We have 4 to 5 years to work through those issues to figure out what can be done to provide services to those jurisdictions. Our commitment, however, is to developing this new assessment model. To the first point that you raised, if I could, I think the question in chat about the standalone NBE might have been a result of Dr. Raymond's very accurate comment that there still could be, quote, standalone multiple choice questions on the exam. And I can see where that might have generated a little bit of confusion. And I think what Dr. Raymond's basically telling you is that item sets that are integrated in nature won't necessarily each and every one of them include every type of item type surround a common set of scenarios or legal resources. But instead, you could see a scenario or a set of resources that generate multiple choice questions. And so obviously, multiple choice questions in some form will remain an item type on the exam, but there will not be a discrete component of the exam that could be characterized as the NBE. Hopefully that clarifies that issue. I think that's right, Dr. Raymond.
Yep, that is correct. And I think that is the source of the confusion that you identified.
Thank you.
So, Dr. Raymond, since you have the mic, there were some questions about compensatory scoring and the request that you elaborate a little bit more about how that might work.
So, yep, a compensatory scoring model, really means that what you do across all measurement test items or subtests is you come up with a single total score. And what that implies is that high performance in one area or on one of the subtests could compensate for low performance on another area or another subtest. At the end of the day, what really matters is that your total score exceeds a single cut score. And that's really the way the UBE works today. That is, for the UBE jurisdictions, if their score across the MEE, MPT, and MBE exceeds some point, somebody passes, even if they didn't do very well on the MPT or the MEE or some combination of that. With a conjunctive scoring model, individuals must pass every component of the exam. So they must achieve a passing score, for example, on the MEE, MPT, and MBE. There are some examination programs that might even say, so the MBE consists of these 7 content areas, like constitutional law, torts, evidence. They might even further go on to say that someone has to pass every one of those areas. That's a harder standard for examinees to achieve. And it has, different pass-fail consequences. Typically, almost always, the pass rate will never be as high with a conjunctive model as it will with a compensatory model. And there are different reasons to employ different types of models. If you truly think that your skills are independent, unrelated, then a conjunctive model may be the way to go, especially if some minimal level of competence is required on each one of those independent components. However, if the skills are interrelated, highly correlated, as they currently are, and as they certainly will be with the integrated exam, then a compensatory model makes more sense.
It's also more fair, Dean Barrows, if I could just throw that in, because you do have, whether it's empirical or perceived, it doesn't matter. But there are people who believe that they do better on multiple choice or essay. And the notion that you have multiple item types integrated into an exam in and of itself is fair. But the notion that you're then producing a compensatory score permits the retained advantage to applicants who might do better with certain item types versus others.
Great, thank you. So let me ask a couple of potentially related questions. One is there's some concern in the comments about students with ADA accommodations. And just, I understand that that's often a jurisdiction-specific issue, but how you're potentially thinking about that in the new test design. And also 2 related questions. I guess 2 comments that come up a lot are that just in talking about the bar exam in general, one is that the bar exam is not closed book. The bar exam is closed book, practice is not closed book. And the bar exam is time pressured in a way that practice sometimes is, but typically is not. And I think that those also, some of those issues have a little bit to do with the ADA accommodation issue a little bit. So I don't know which one of you might want to just take a stab at talking about those a little bit.
I can try to answer the questions about the ADA. I mean, as we currently do for the current exam, we produce the exam in alternate formats. So the jurisdictions do receive the requests for accommodations, and they make those decisions about whether someone should receive accommodations and what is appropriate. They then order test materials from us to be able to meet whatever accommodations they need to provide to the candidate. And so, of course, with a paper-based test, sometimes those accommodations are that the candidate needs to take the exam on a computer or to use assistive technology. And we have provided materials to accommodate that in the paper-based administration. And when we move to computer-based delivery, the reverse may be true. There may be candidates who have a disability that warrants receiving the test materials in a paper format. But certainly with any new testing program in particular, but as new technologies come along that allow new ways to address disabilities. I mean, this is just something that we always have to stay abreast of and be prepared to be able to try to deliver the exam in alternate formats for people who need it. And that's something that will be part of implementation as well. As we're developing the exam and thinking about delivery, we'll also be having to think about whether and how we would be able to make that same assessment, possibly using an alternative version of the test materials. So that's something we're used to doing and will continue to do. And I have forgotten what this second part of the question.
Greg was going to speak to the issue of closed book, open book, and I think then the other piece of it had to do with kind of a speededness issue, a time constraint issue. But Greg, if you want to go ahead with the closed book discussion, and Dr. Raymond, you may have a comment or two on that subject as well.
And thank you. I think one of the things that came out of the test design committee this summer, or let me back up. One of the concerns we all have with the bar exam is that no licensing instrument should award memorization qua memorization. That someone should be happy that they got some obscure question about rules against perpetuities correct. And so when you see the marriage between foundational subject matter and foundational skills and in the eventual development of item sets, you'll start to see, as what Dean Barrows said, that there will be an occasion where we will move very strongly to an instrument that does not reward that memorization, which will impact the need for an applicant to take an 8-week bar review course. So, and I want to dovetail that into something in the chat and then come back to the notion of closed book, is that I certainly would not advocate for the new generation of the bar exam to only be taught in an academic success realm. I think that the existence and the phenomenon of an item set could be extrapolated across many doctrinal courses. It can be with the foundational subjects, it can be with upper level curriculum, but it's the combination of those various types of items that lead ultimately to sort of this practice-oriented goal is what I think is important. Specifically with respect to the idea of an open book or closed book exam, there was a very robust debate in the test design committee after we got the blueprint design report about can we have some sort of semi-closed universe, all of us accepting that the MPT would be the basis from which we develop these proposals. And if you look at the preliminary report, there are these foundational subjects that will be tested, but the bar exam may also test on subjects outside of those subjects, but it will provide some form of a library as we know it, or something to be able to assess those lawyering skills. And in that vein, I see that as not closed book. Essentially, you have the file in front of you. For the foundational subjects, again, they are threshold subjects. It's the IALS report, the idea of sort of threshold knowledge, like subject matter jurisdiction, et cetera.
And to that point, I understand that the proof's going to be in the pudding when we get through implementation and we work immediately on that important phase of the development of content specifications. And, what we have to ask of you is to appreciate and respect that the same commitment that has brought us through these past 3 years will continue the next 4 to 5, and that we will still be engaged in outreach and collaboration with the important voices in the room to help define those foundational concepts and principles that from a common parlance, no one would characterize as memorization in the sense that it's rote memorization without value, but there are just certain foundational things that one would expect a lawyer to know. And those are the concepts and principles that would be tested on the exam without necessarily providing the library in order to go find the essential elements of a contract, for example. But that will be worked out. And I think in the end, you're going to be really pleased if you had any way of knowing how much time has already been devoted to the topic of implementation around the subject of content specifications. I think you'd be pretty pleased about that because it's an important focus for us. The other question that you'd raised, Ben, and Dr. Raymond, maybe you can help speak to this, has to do with this notion of time requirements on a high-stakes licensure exam. And we kind of translate that into speededness, and do students really have enough time to take these materials? Because in the real world, maybe you don't have those kinds of time constraints associated with writing an essay or a letter to a client, et cetera.
So from my experience, at least on the MBE, our time constraints are fairly generous compared to other licensing and certification exams. We allow almost 2 minutes per item. I think it's 1.8 seconds, which is on the generous side. And I might refer the audience to a book that was just published on examination timings. I think it's the book is called Timing Considerations in Exam Development. And I am happy to say that the book is a consequence of a conference that I put together when I was at the National Board of Medical Examiners. And it's a complicated issue. People who know more and who are more competent are able to work faster. On one hand. On the other hand, you don't want to impose artificial constraints on someone's ability to demonstrate their knowledge and skills. So there's that issue going on. And, then there's just also the practical issue. And we tackled this issue head on at the National Board of Medical Examiners with allowing extra time, because allowing extra time meant we were buying more seat time from our test delivery vendor to allow that to happen. And the question arises, how many examinees are willing to pay for an extra half days of time to lengthen the exam? So there are many nuanced issues in there, and there are also issues related to cost.
Great, thank you. So I'm not sure this is exactly within the purview of anybody who's actually on the call. So potentially Judge Martin, I don't know. But there have been some cut score questions about, the process by which jurisdictions are going to set the cut score. Judge Martin, do you want to address those a little bit?
Sure. One of the items listed on the implementation or next steps slide involved the fact that we will work with jurisdictions as they set their pass score. We anticipate, in fact, I think it would be unusual if we weren't anticipating the notion of providing the service of a standard setting exercise. And although we don't control what jurisdictions do, our hope would be that because we're moving to an exam that is so very different from the current exam and that will require a new score scale, that is a given. And because we're now in a different world where you have so many jurisdictions who are committed to uniformity in terms of exam product and the notion of portability of exam score, that we'll have a lot of takers with jurisdictions interested in participating in that standard setting exercise, where one would hope we would be producing data about a range of scale that would be a cut score for jurisdictions within which one could fairly say there has been demonstrated minimum competence. We can't force that on any jurisdiction, but we would strongly encourage, and at a minimum would be working with jurisdictions as they work to set up their pass scores to be sure that they're doing so as systematically as possible. In a perfect world, there'd be a single cut score. We don't necessarily control the outcome of a perfect world, but we will be doing anything and everything we can to provide the services necessary to put our jurisdictions in the best possible place to set cut scores that align with what we please or what we believe to be fundamental fairness, and again, the purpose of the exam as we've articulated it.
Super, thank you. So let's just assume this is a 5-year process, might be a little bit longer, a little bit shorter. One of the things that's come up in the chat a lot is so thinking as faculty members, thinking about preparing our students. One person in the chat mentioned, if this is the exam format, this is something that we probably want to start working with our students about from day one when they first arrive. So what can faculty expect as far as getting potential material from sample questions, guidance, to help us prepare our students for this new exam?
I mean, that is also part of implementation, and obviously the steps that Judge Martin's talked about in terms of nailing down the content specifications, the breadth and depth of scope of coverage will be an important first step. We'll also, however, begin playing in the sandbox. Dr. Raymond will be leading that effort. In fact, some of you may have seen NCBE is hiring. We're adding staff because we've got to keep the existing trainings running on time, just as we always do while we build this new exam. But we are very aware that stakeholders, not just the educators, our jurisdictions also are quite anxious to see what this will look like. And so we're very sensitive to getting some examples out there for everyone. We also are very, very aware of the fact that, you're going to need study aids, the bar prep companies, to the extent they still provide support for students preparing for the exam, are going to need to get ready. Everybody's going to need to get ready. So we will be, as we can, developing study aids and publishing as the same approach we've taken to the testing task force study. There will be an implementation website. And as we're doing this work, and we have materials and information to share with the community, it will be posted and published on that website. We'll want to, of course, provide some materials to students in our e-learning system Bar Now, so that they can have an opportunity to take practice exams before the real thing. So part of the implementation.
Thank you.
I mean, I would say that as soon as reasonably possible, we're going to try to get out examples to people. I think the other component that we mentioned is field testing. Field testing would be along the line of pre-testing, only you're not in a position to pre-test a brand new bar exam on the current bar exam. But field testing could, for example, involve piloting with some of our law schools. It could involve all kinds of creative ways that we provide access to these potential new materials to see how they test, what response there is to them. We're going to be looking for all kinds of collaboration along those lines. So we hope whenever we make that ask, and many will be raising their hands to lend some assistance with all of this.
Yes.
Great. Sorry, go ahead, Greg.
No, I was going to say, I personally see that in the 4 to 5 year time frame, that's going to affect some curricular concerns of law schools. I think we're all ready for that discussion. We can align how that's going to happen with the future of practice. I see this as an invitation to have innovative discussions with our clinical faculty Just sit down with some MPTs and say, how can we make item sets out of this? So I think it will be cause for collaboration.
Great. So just one last quick question. There was a question about the diversity, not of all sorts of the people who are involved in these processes. And I'll just say from my own, the one that I participated in, it was incredibly diverse on every conceivable metric, race, gender, but also practice backgrounds, geographical. I guess, Kelly, you probably had a role in putting some of these together, and you want to just briefly talk about it. I was very impressed at how thoughtful and how diverse the constituencies.
Yes, and that is something we certainly care a great deal about. We'll continue to do that in inviting subject matter experts, educators, practitioners for implementation. But yes, the focus groups we convened to help us craft the practice analysis survey were diverse, but also as you two know, the test design committee, that was 20 stakeholders. Of those 28, 10 were women and 7 were people of color. We had 11 that were educators. The others were bar examiners, administrators, or justices. Our blueprint development committee was 17 lawyers, 14 of whom were female, and 10 of whom were people of color. Anytime we put any working group together, we want a diversity of backgrounds, views, experience. That is going to provide us with the best information. So that's always very important to us.
Well, thank you. I see that we're out of time. I want to thank all of our participants, our panel members, but also thanks to all of you in the chat for your questions. I really appreciate it. So these 2 panels back to back hopefully are just the start of more conversations. My personal agenda in helping putting these together was to increase the communication between bar examiners and law faculty. So thank you all. Have a great day. It was good to be with all of you today.
Thank you very much.
Thank you.
Bye-bye.